I may be permitted to move on unlisted. This extremely urgent, my lord. I am doctor by profession. I am running a clinic as a tenant. Already suit is pending. The landlord disconnected my electric connection. I am praying leave unlisted. Today,
No, not today. Tomorrow.
without electricity.
Tomorrow.
Subject to convenience, may be taken as a last.
You have served.
I requested Mr. Mishra to take the copy. He accepted. He will accept.
Mr. Mishra.
But I have to take instruction.
He has to take instruction. You take instruction tomorrow.
Not.
Let him take instruction so that.
My lord, item number 1, my lord, I am for the petitioner.
Any other mentioning? Item 1 WPS 703 of 2024.
My lord, there was a direction, my lord, asked by your lordship in item number 1,
File my affidavit.
directing the respondent authorities to file a written affidavit in opposition on the last occasion. Pursuant to an order. Okay.
Yes. Yes.
My lord, pursuant to an order dated January 7, 2025, my lord, your lordship was pleased to direct the administration and the private respondent file the affidavit in opposition, my lord, within fortnight.
Yes. Where is the affidavit in opposition?
Counter rate petition, sir. Subject to my lordship.
Was it 4 and 5? I have to file the lead petitioner, my lord. He himself obtained building for single floor. Total violation.
Your reply is also not here. Is there any reply? Oh, yes. 4 5.
My lord, in my reply, my lord, lordship kindly come to.
All right, you place your file your affidavit in opposition. We'll see. Learned counsel for the
My lord.
administration seeks and is granted for the time of 2 weeks to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List before the next available circuit.
No, I'll file my affidavit there.
That you have already filed must have been taken in the. This is already there on record, right? Must have been recorded.
File.
Should I record that, or it must have been taken in registry? No, the affidavit in opposition filed by the respondent number 4 and 5 is already on record. Do you want to file your objection? Reply to the affidavit.
My lord, my lord.
Learned
My
counsel seeks and is granted 2 weeks time to file his reply to the affidavit in opposition filed by respondent number 4 and 5.
My lord, some my lord positive direction, my lord, be passed, my lord, upon the opposite party respondents, my lord, because they have taken lots of time, my lord. They have not filed their opposition, my lord.
So I have instruction.
Some change in direction, my lord.
Learned counsel, this is the last and final opportunity. Learned counsel for the state is granted last and final opportunity to file their affidavit in opposition. उसके बाद कर देना reply if any. within.
I'm extremely obliged, madam. Deepest respect, madam. Grateful.
TBMC, administration is not margin. They have to here speak some.
Also, I am the state respondent also.
File has still not reached.
My lord, then my lord, next circuit, my lord. My lord, there was a direction of the Honorable Supreme Court, my lord, to file a application for anticipatory bail, my lord, before the principal judge, before the principal bench, my lord, at High Court at Calcutta. Accordingly, the matter was filed, my lord, and the matter was taken up by His Lordship, the Honorable Justice George Shandikar, my lord. And he passed an earlier order that,
The records of
that
the.
the, my lord. My lord, only extend the interim order, my lord.
2025, the same has not yet been received in the registry. Full stop. Let this matter be listed before the next available.
Lordship, interim.
My lord, only one humble indulgence, my lord.
Lordship.
My lord, the interim order granted by the Honorable Supreme Court and the principal bench, my lord, be extended.
Chance on, because the anticipated bail investigation going on, cognizable offense have been made against him.
Sir, what? Only if the record comes.
Lordship, I am, that, but on chance on Monday, last day, one.
My lord, only my lord, the interim order be extended, my lord.
Lordship,
Which has been
Order is itself.
order passed by the Honorable Supreme Court.
thereafter, Honorable High Court also passed.
Exigent circumstances, the investigating agency shall not arrest the present petitioner till the matter is taken up for hearing by the circuit bench. This is the order, my lord.
Much obliged, Lordship.
If the report comes, we'll.
Lordship, much obliged.
My lord, kindly records, my lord, that the interim order.
Oh, sir, it is already recorded in the order that till the time.
I am so grateful.
I don't have to record anything.
I am grateful, my lord. I am so grateful.
It is written.
I am so grateful, my lord. I am so grateful. My deepest respect, my lord.
For the additional.
Yes.
Yeah, enforcement.
Yes.
Extend the right for the electrical issue in the.
Yes. What are your instructions, sir?
Lordship, I have already submitted a document report which has been furnished by the assistant engineer. The inspection of the house of Sri so-and-so, R.O. Kusnawat, conducted by the junior engineer and found that the applicant has not completed the house, which is not suitable as per safety point of view for providing the electric connection in the structure. Upon that, they were directed to file.
Based on that, objection is on the basis of report. The petitioner has moved the exceptions to the report that is dated 19th June 2025. Whereby,
And moreover, whereby it is agreed by any order.
but I
There is CGRF is there. Let him approach before the CGRF. This court is not fact finding.
my application was rejected on the basis of the concerned regulation clause 5.6 of the.
No, your application is rejected. Please see the reply which has been filed by them. They are saying that the house has not been completed and that is why it is not suitable as safety to provide the electricity connection.
That is complied. That has been conveyed.
Now this disputed question of fact, this court can't get into it.
My lord, based on that, I also moved the exception application.
Yes.
So the court that each and every formality has been complied. That will be considered.
Let him go before
That will
the
be considered.
CGRF.
Where's your exception?
My instead petition may be allowed and disposed of with the direction upon the respondent to kindly go through, have a physical inspection. Thereafter,
They
they
have
can pass.
already done the physical inspection. After
That
we
is
have
the-
seen
that
the
is the
physical
previous-
objection, when
that
I
is
have
the-
raised the
Just a
objection,
minute,
they have
just a minute.
constructed.
Kindly go through.
So he has already constructed. You please see
No,
that.
I cannot say right now.
I will pass an order.
I have seen the photograph.
Previously, after
We have already rejected, and that rejection order is not under challenge before this honorable court.
Because the petitioner has moved the application and the same has been rejected on the ground of the clause 5.6 of the JERC. So that has been, and
That has
and
been
to that-
available before the
My lord,
CGRL.
let me submit my contention before this honorable court. Why the interference all the time between my submission? They have
That-
filed their report during the pendency of the rate applications, and I have filed against that report. I have filed my exception, whereby I have.
Where is the order which you are, there's an order which has been passed by them? Where is that order of denial of the electricity connection?
It is at page number 20 of the report. P3, except P3.
This is not, this is not the ground. All right, take down. The
My
petition,
submission may be recorded. Petitioner is having another alternative remedy, so this writ petition is not maintainable. He has to approach before the CGR. Consumer
My
Redressal
lord,
Grievance.
my lord, in the same nature of contested.
all right. Heard you.
Yes.
Take down. Learned counsel for the petitioner has preferred the present writ petition, seeking direction to the respondent authorities to provide electricity connection to the petitioner's premises. Full stop. It is a case of the petitioner that he is an encroacher on government revenue land bearing survey number 145/P, measuring an area of 250 square meters, situated at Tushanabad village, near Gram Panchayat Tushanabad, under Ferrarganj Tehsil, South Andaman district. It is the case of the petitioner that he has constructed a house on the said land and seeks electricity connection to the said premises. Full stop. The learned counsel for the respondent has filed their affidavit, report or affidavit? Report by way of an report wherein they have stated that after due inspection, it was found that the petitioner has not completed the house, and thus, from safety point of view, providing electricity connection will not be suitable to the said structure. Full stop. Learned counsel for the petitioner has filed his exception to the said report, wherein photographs are annexed, which shows that the petitioner has constructed a dwelling house wherein the petitioner is seeking the electricity connection. The said fact that there is no structure suitable for grant of electricity connection is disputed by the petitioner. Full stop. Learned counsel for the respondent states that the present writ petition is not maintainable since the petitioner has got alternative remedy to approach the CGRF, Central Redressal what is it? Central Dispute Consumer Redressal Grievance Commission.
Authority.
Commission or authority? CDRF.
Forum.
Forum. CDRF. Forum. Full stop. This court has heard the counsel for the parties and has perused the materials on record. It is noted that the petitioner is seeking an electricity connection to the dwelling house constructed by him, which is evident from the pictures which has been filed by the petitioner. Full stop. The learned counsel for the respondent is directed to provide the electricity connection to the petitioner in case the petitioner is able to fulfill all the requisite conditions. Full stop. The application of the petitioner was rejected as no objection certificate in terms of JERC Regulation 2018, Clause 5.30 was not procured. No objection certificate from the owner of the premises was not procured by the petitioner. Full stop. The said regulation, it is not applicable anymore.
It is applicable, but there is a decision of this.
The said regulation. Where is that? They have this court earlier, while dealing with the said contention, had passed an order in WPA number 216 of 2025 by order dated 11 July 2025, wherein
But in matter of WPA 216 of 2025, page number 2.
wherein the court had observed that the court had observed, इसको tick to tick कर लो, page 3, यहाँ से यहाँ. In view of the said finding, the rejection of the petitioner, the rejection for grant of electricity connection to the petitioner is hereby set aside.
Prior to the order passed by this honorable court. Rejection order was the prior to the
All
order
right.
passed by this honorable.
It's all right.
In the month of April.
In view of the said legal position, the objection of the petitioner regarding non-fulfillment of JERC Regulation 2018, Clause 5.30 is not in accordance with the established principle of law, and thus the petitioner is directed to provide the electricity connection to the petitioner within a period of 4 weeks. 4 weeks from the date of receipt of this order on compliance of all necessary formalities. With the above direction, the presented petition is disposed of. This is
Take instruction with regard to settlement. This is the present format after the order passed by honorable General. We are not seeking any no objection or settlement. Just we want that whether it lands belongs to whom. If it is a revenue land, then it's okay.
No, this will not do. This is still going back to that circular.
My submission may be recorded. We are not asking for settle position and no objection certificate. That was the difficulty in the circular.
All right. Yes, make the arguments. Readings are complete in this. We'll finish it off.
Fine.
Yes.
Honorable, kindly take out my supplementary article. Let me just take your lordship through the documents. First and foremost, at page 26. This is the extract from the Electricity Act 2003 as amended in 2007. And it will see section 43. Now, section 43 as it originally stood had two provisos. On the next page, your lordship will find the explanation which was added in 2007.
Yes.
So this explanation meant an application is an application complete in all respects in the appropriate form as required by the licensee, along with documents showing payment of necessary charges and compliances. Now, in this background, there is another statute which is at page 29.
Yes.
Now, these are the rules called the Works of Licensees Rules 2006.
Yes.
Under these, my lord will see Rule 2(1)(b).
Yes.
Occupier of any building or land means a person in lawful occupation of that building or land. This used the word lawful. Now, in this context, the matters have been coming up before this honorable court until in 2011, it is decided by a constitution. This is at page 36.
Yes.
So at page 36, Madam will get the order. This is reported at AIR 2011, Calcutta, page 64. Two questions are framed at page 37. The first question is whether an unauthorized occupier who is occupying government revenue land can ask for electricity. The second was Article 21. The court considers the entire matter, and the finding of the court ultimately is there at page 46, paragraphs 16, 17, 18, and 19. Basically, the word lawful that was appearing in the rules of 2006 was clarified, and this honorable court looks at it in the light of settled possession rather than lawful occupier. Because the moment lawful occupier is read, no encroacher can ask for electricity. Thereafter, till 2018, various orders of mandamus were passed. One set of the last orders is at page 48.
Yes.
That provided you are in settled possession and you are fulfilling the requirements of Abhimanyu Mazumdar's judgment, you will get electricity, and mandamus was issued.
Yes.
Now, in the meantime, the JERC comes out with its rules in 2018. Now, the extract of this is at page 49. The copy of the JERC regulations we have already submitted, and I believe it is with the record. If necessary, I have a fresh copy with me. JERC. And one of the extracts that I'm pointing out is at page 49. Kindly
Just
see.
a minute. I think it just yes. Yes.
So, madam, at page 49, the extract is there. The lordship will get the same.
52.
JERC.
Right. Occupy.
2.3.
Yes.
Under 2.3, my lord will see first of all 4. Applicant means,
Just a minute. Just.
and I can show lordship from the petition or from the
2.3 applicant.
my lord.
2.4 applicant.
2.4.
2.34.
Subclause 4. applicant means an owner or occupier. Now the word lawful is no longer there. Thereafter, my lord, will see 5. Application means an application form complete in all respects in the appropriate format as specified in this supply code. Number 6, application form means an application form complete in all respects in the appropriate format as required under this supply code. Then my lord will see 2.320, consumer. Consumer means any person who is supplying. So there has to be an existing connection to be a consumer. Thereafter, my lord will see subclause 52, occupier. Occupier means the owner or person in occupation of the premises where energy is used or proposed to be used. Again, the word lawful is no longer there. Now, in this context, under chapter 5, the procedure is laid down for release of new connections and modification in existing connections. My lords will see under 5, there are several clauses. The relevant one is 5.30, where the list of documents are given for acceptable proof of ownership or occupancy. Now, under these 1, 2, 3, 4, 5, 6 mentioned documents, and 7 says an applicant who is not an owner but an occupier shall, along with any one of the documents listed at 1 to 6 above, also furnish a no objection certificate from the owner. Now, the difficulty is, my lord is aware under the land revenue regulations here of 1966, all land is vested in the administration. Therefore, every person who occupies land here is a tenant. And therefore, he must get a no objection certificate from the administrator representing the administration. Over this is the primary difficulty which arises. Now, in the meantime, my lords will see at page 52, a new set of regulations is issued by the JERC. Now, this is the Consumer Grievance Redressal Forum, where my learned friend is repeatedly talking about the alternative remedy. So here, my lord will see at page 52, the regulations are there. Now at page 55, 3E, grievance means and includes any complaint relating to fault, imperfection, shortcoming, inadequacy in the quality, nature, manner of performance, etc. Now in this background, the administration needs to issue.
But this will only be after the electricity has been granted.
Now, this is what the High Court has said in other judgments which are placed. The High Court has said that until you are a consumer, and consumer means a person who is supplying electricity, the question of consumer grievance doesn't come. Now, that is something which is implicit in the orders of this court, which the administration is seeking to not do. Now, in the meantime, my lords will see the central government issues a notification with regard to the rights of consumers at page 82. Once again, we have to see 3 very important things. Number 1 is at page 82, kindly see definition 2F. Again, consumer is defined as a person who is supplied with electricity. 2K, occupier means the owner, tenant, or person in occupation of the premises where electricity is used or proposed to be used. The word lawful is not there. Now, my lords will see at page 83, rule 4, new connections. At subclause 9, it says for new connections up to a load of 10 kilowatt or such higher load as may be specified by the Commission, the application form shall be accompanied with only 2 mandatory documents. Number 1, identity proof. Number 2, proof of applicant's ownership or occupancy over the premises for which new connection is being sought, or in the absence of any proof or ownership or occupancy, any other address proof not given as part of identity proof above. For new connections beyond specified load and modifications, the Commission shall explicitly state. So the requirement of 530 in 2018 is watered down here. Thereafter, the administration issues its own regulations at page 92. This is with regard to the consumer forum which is created, and this is where something very unfortunate happens. So in June 2023, the forum is set up with 3 members. I will see at page 92, 4th paragraph.
Yes.
1 chairman, 1 member, 1 independent member. This is very vital. Now, after that, the CGRF starts functioning and takes up matters. Now, at page 94, your lordship will get the extract of the circular we've all been talking about. This circular, which is issued on the 9th of October 2023, was not available, but with the greatest of respect, we have secured a copy. With the permission of the court, I will place it. The reason for page 94 is we couldn't get it, and so we have relied on the extract which is there in the CGRF order. But in the circular, my lord will see the requirements. A, residing in encroached revenue land only, not applicable for forest area, that's fine. B, must not be a government servant. C, only for domestic purpose. D, now the problem is here. D1, must submit application for new connection in the prescribed form for new connection along with supporting documents, identity proof, affidavit. All that is fine. 2, the applications shall be provisionally accepted and the application shall be forwarded to the concerned revenue authority for confirmation whether the applicant is in settled possession or not, as defined in the judgment of the Honorable Supreme Court, so and so. 3, after confirmation from the concerned revenue authority, the application shall be formally accepted and processed further in accordance with the JERC Regulation 2018. This circular, therefore, seeks to introduce a new element which was not there in the 2018 regulations or in the 2020 Rights of Consumers requirements of documentation. So this circular, which never saw the light of day, is being relied on repeatedly by the administration in order to say that till we get a report, we are not in a position to say that you are in settled possession and therefore your possession is not settled, therefore we can't grant you electricity. The corollary to this matter, with the greatest of respect to all concerned, it brings in a third party extraneous consideration. So the file goes to the Tehsildar and the file remains lying with the Tehsildar for months on end. In practical purposes, till the Tehsildar is met and certain requirements are fulfilled, nothing happens. Now, very ironically, at page 95, your lordship will find the order passed by the full bench of this grievance forum. The relevant portion starts from page 96. This is an order in complaint number ANI CGRF 303 of 2324. And the date of the order is 5th of December 2023. Now, this is a person who applied for electricity. The circular was shown to her. The circular was used as a means to deny electricity. What is very interesting is that, first of all, at page 96, your lordship will get all 3 members of the commission were there, right at the top. Now, from there, my lord will come to page 100. The second paragraph at page 100 deals with this particular circular and deals with this discussion about this circular. Now, I'm sorry for the quality of the copy, man. This is the best we have been able to get from the website. Now, the court considers the application forms under the 2018 regulations. It goes through the entire matter relating to the judgments that have been passed. If your lordship comes to page 104, there is a discussion with regard to chapter 5 of the JERC regulation with regard to the conditions for grant of connection. The procedure that is followed is in detail discussed up to page 107. Then at page 107, the last paragraph deals with Abhimanyu's judgment. It quotes Abhimanyu's judgment. It reflects thereafter the section 43. It then discusses how Abhimanyu Majumdar's judgment dealt with the word occupier without including the word lawful occupier. It dealt with the entire evolution of law. And very interestingly, kindly see the observation that is there at page 111.
It cost that 23. Can they do
But
that?
what is important is the first paragraph also. The independent member does not agree to the point of making a policy decision for encroachment cases of Andaman Nicobar Islands, as there are precedent decisions by the Honorable High Court and Supreme Court protecting the basic rights. This independent member is very much present and gives a dissenting view, saying, dissent to what? They are saying send it back to the administration to form a new policy. She says nothing doing, follow the High Court order. And ultimately, this is also quashed and set aside. My note is getting that in the next page as well. Now, at page 114, my note will get the situation that stands in 2024. Now, my note will bear in mind that already the circular is gone. They haven't
Yes.
challenged it.
Yes.
In 2024, WPA 194, which is Santosh, is heard by a single bench of this court. Now, your Lordship will find from page 114 that there was a reason the court was so upset, because the matter was being called up and someone was not appearing. Thereafter, the court decided enough is enough, we are going to proceed. The court goes into grave detail at page 117, paragraph 8. The
Yes.
court discusses Abhimanyu Mazumdar. And paragraph 14 onwards distinguishes the full bench of Abhimanyu Mazumdar by saying that the amended version A was not there, B, the 2018 regulations were not there at that time, and therefore it has no application, and 3, the 2006 rules are not relevant in any form because they deal with some other subject.
Yes.
On the basis of this, Abhimanyu is sought to be distinguished. The court then goes into various other provisions, goes into the regulations, goes into 530, and ultimately says electricity connections cannot be provided in this format. And one will find that at page 136, paragraphs 27 onwards. 28 says that you don't have any right to ask for a mandamus,
Yes.
and you have not complied with giving the documents, therefore you don't have a right to ask for electricity, and therefore the writ is dismissed.
Yes.
Now at page 139, the next circuit which comes deals with a whole batch of matters in a case called Sushil Lakra.
Yes.
Now in Sushil Lakra, the order is passed on June 19, 2024. Here, my lord will find that since Bhattacharya considers the 2019 CGRF, your lordship will find at page 143 the same argument for alternate remedy is there. The
Yes.
court says nothing doing. The same argument of 530 is there, nothing
Yes.
doing. And at page 145, this court answers what Abhimanyu left unanswered and says that electricity is a right which is part of Article 21. It deals directly with the right of a person. More importantly, my lord will find at the bottom of page 145, the story of alternate remedy is completely washed away because the court says a grievance means something which is there once there is supply which is faulty or not proper. So on the basis of that, page 146, the court says the premise of the expression grievance takes into consideration cases where there is an existing relationship of consumer and licensee. An applicant for electricity connection is yet to have such a journal relationship to the licensee, and as such cannot be termed as a consumer. Therefore, there is no question of alternative remedy. The court allows the writ petitions and issues a mandamus to give electricity positively within a fortnight. Now, in this background, may I say this? The administration has repeatedly chosen to adopt those positions which are convenient. So the court is placed with a situation where different circuits which come are shown the judgment which says Abhimanyu is wrong and not the others.
I never.
So I have not said anything about you, Mr. Mish. Now at page 148, the court comes and finds that there is a situation where this judgment has not considered this, that judgment has not considered that. I would find that at paragraph 6 and 7. And the court records this at paragraph 8 that Santosh was not cited in Sushil as well, or even in the subsequent matter. So whatever I'm saying, it's not directly against my girlfriend, but it's the observation of the court. Now, once again, the court looks at the term occupier as per paragraph 9, going by the new supply code of 2018.
The court says very clearly it is not qualified to be a lawful occupier. This was already elaborately dealt with in Abhimanyu. Abhimanyu is very clear. Abhimanyu has not been set aside. And in fact, the court says that in Santosh, the coordinate bench, single bench, did not properly examine Abhimanyu. On this basis, the court says that I am of the view that Abhimanyu is still good law. I do not agree with Santosh. I agree with Shushila. Now, in this background, the court passes an order and directs a mandamus again 10 weeks. Now, why have I said there are difficulties here? The difficulties are threefold. The first one is at page 152. Now, when people are being relegated to the alternative forum, kindly see what is happening. This is an order passed. My lord will see two members of the forum are there. The independent member who has dissented with the need for policies by the administration and circulars is absent. This order is passed after the previous order, once again relying on the same circular and implementing it. The administration, the assistant engineer, at page 154, 153 and 154, the reply of the respondent licensee, my lord will see assistant engineer supplies various documents, including at page 154, that same circular, which the same forum has struck up. And this makes it different on the grounds of that circular. Now, let me pause here for a moment and just rely on this document which has been handed up today. Now, my learned friend is saying that we are not looking for any further requirement from the revenue department and things like that. But unfortunately, this document will not do for the simple reason its foundation again is that same circular. Now,
Yes.
in this background, my lord will find at page 159. These are orders passed with regard to various other applicants. This is a person who is related to me, therefore I have access to it. Now here, my lord will find at page 159, again they are relying on that circular, again they are relying on the revenue department, and they are saying that because we can't determine settled possession, we can't give you electricity. So this is not about verifying that you're an encroacher, what is your ownership, what are your rights. This is about settled possession, which is a sole province of a civil court being decided by the tehsil. Now, at page 161, we have made an application under the RTI, or we issued a legal notice. Now, kindly see the response we are receiving. With reference to your notice, the court judgments are referenced, and they say, the third last and second last paragraphs, that we will follow 9th October 23. And this is issued with the approval of the legal cell, which means the electricity department is advised to follow this particular circular, although the circular is no longer there. And this is why in certain places the circular is still being used and shown, including before this honorable. Now, in this background, my lord, the only other thing for me to say is, I have shown up to July, but I was not aware that in August, my lord Justice Rao has passed an order, which in the preceding matter has just been placed.
Yes,
Again,
just give me that order of Justice Rao. You have a copy.
Again, in this matter, my lord, I've had a quick look at it. It's indicating the same position as is there in Abhimanyu, Sushil, and MS Rajendran. But once again, that harmonizing of the different points is absent. Now,
Yes. Here.
now, the only other argument for me to make is that so far as their affidavit is concerned, three things are quite shocking. The first thing is they are relying on the forest case, T.N. Godavarman's Vilmalpal. This case has nothing to do with electricity connections for the simple reason that it is dealing with issues of encroachment, compensatory allotments, things like that. this issue has been specifically dealt with in Abhimanyu. The question doesn't arise. The second problem is with regard to paragraph page 5, paragraphs 4 and 5, where they are trying to say that your application is not complete because you don't have a no objection from the administration, which is a twisted way of coming back to 530, which has already been said to have no application. A. B. In doing this, they are ignoring the 2024 as well as the new guidance. The third problem is at paragraph 10, page 8. This is where the respondents selectively say that the judgment in Santosh is correct, the judgments in Shushil and MS Rajendra are incorrect. I do not understand how the state can say this without challenging these orders. And finally, we have made it very clear, we have submitted our written notes where we have demonstrated the manner in which this evolution has been sort of derailed, for want of a better word, because the exact position is not coming forward. Now, today, for example, when this document is being placed by the state, I have grave objections to it for the simple reason that you're going back to that. You're trying to circumvent the High Court's orders without challenging them. Now, my understanding of the law is very clear. If there is an order which any party is dissatisfied with, you can challenge it or you can comply with it. Now, in absence of a challenge and Abhimanyu holding good, this position cannot and does not stand.
Yes.
These are my submissions.
But kindly, first of all, kindly come to the writ petition. What is the share of the writ petitioner in the writ petition?
Yes.
There is no challenge thrown to all these things in the writ petition. How? By filing supplementary affidavit, you will bring all the document, and some of the document is not relevant to the writ petitioner. It is not a public interest litigation.
Yes.
And moreover, CGRF doesn't have power to pass the
Did you
circular of.
have you challenged that order?
But thereafter CGRF once again they have quoted that.
Have you challenged that order of CGRF? You can't.
But because they don't have jurisdiction, why I will challenge that?
An illegal
Their
order,
lack of-
an
their lack of jurisdiction.
illegal order you will not challenge. Lack of jurisdiction has to be set aside, sir. Is this your understanding of law? That if an illegal order has been passed and you feel that they don't have the,
CGRF has relied upon that circular.
they have relied upon the circular because probably this has not been quoted. So you will choose whichever you want to rely upon.
No,
This-
but they are not.
That's exactly
choosing-
what you are doing.
They are not choosing it. And moreover, Lord should kindly see the prayer. What is the prayer?
Yes.
And moreover, Lordship, while we are taking the clarification from the revenue department, this is the letter which I have received in the year 2020 for July.
Yes.
How we can know that that is the land of forest department or revenue land? The writ petitioner has mentioned 226 of lead fee, but in that area that survey number is not there in the revenue record.
Yes.
And thereafter a report was obtained from the divisional forest officer. It's all reserve forest. For that purpose, we are seeking that whether it is a revenue land and nature of the land. We are not seeking for right now, we are not seeking for settled possession of no objection from the Tahsildar. So as such, the order which has been passed by the assistant engineer, that may be set aside, we will reconsider his case.
All right. Anything else?
With regards to CGRF Lordship, one D, 3D, complaints. 4th point, any application for a new connection for the supply of electricity. They can challenge it if that has.
Where are you reading? Which page?
Lordship, I have separate copy in the supplementary affidavit, some documents are missing. May I place?
Sure,
Lordship?
sure. What are you showing?
Govinda. Come.
This has already been dealt by Justice
Purchase.
Sabisa, yes.
Fourth one, complaint, fourth one.
An applicant for new complaint.
Yes, that has been discussed together with 2F, which is definition of complaint. Complainant with complaint.
This has been dealt by Justice Bhattacharya.
Let me go through it.
That's already there.
In the supplementary affidavit, all the document is not there.
Yes,
Scanned
communicated to me and I have given my
Scanned copy has been given, but no clear copy.
I'll keep a copy of this. You have
I will ask the department to give me copy.
CAV.
That's it.
Yes.
By considering, by passing the judgment of this letter dated 22 July 2024, may kindly be considered. Just now I have handed over.
The letter which I have handed over.
Lordship, 22 July 2024. Why we are seeking for clarification from the revenue authority, whether it is a forest land or revenue land, nature of the land, that's all.
So this take care of.
There was the JRC regulation if it is necessary, but I think.
I am. Number 5 is also electricity matter, right?
Lordship.
Who's there? So
But
madam-
it has not been rejected.
Not been rejected.
It is still pending with us.
So decide.
Lordship.
The petitioner has preferred the present writ petition seeking direction to the respondent to provide electricity connection in the dwelling house of the petitioner standing on survey number 249/T, area 150 square meters, situated at Kaju Basti, Dairy Farm Village, Vijay Puram Tehsil, South Andaman District. It is a case of the petitioner that they have occupied a piece of government revenue land at the above mentioned site. Full stop. Petitioner states that they have constructed a residential dwelling unit at the above mentioned property, at the above mentioned site. Full stop. They further state that they had made an application for grant of electricity connection through online mode on 6/3/2025, but the same have not been, but no action has been taken by the respondent on the said application. Full stop. Being agreed by the inaction of the respondent electricity respondent administration, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent states that he is ready and willing to decide petitioner's application dated so and so. What is the date? 6th of March 2025, within a period of 4 weeks. Full stop. Learned counsel for the petitioner states that he shall be satisfied, is ready and willing to decide the petitioner's application. Kar dena. Full stop. Learned counsel for the petitioner states that she shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs the respondent to decide petitioner's application dated 6/3/2025 within a period of 4 weeks after affording an opportunity of personal hearing to the petitioner or any other stakeholder by way of a speaking order. With the above direction, the present writ petition is disposed of. All right.
I have not been.
No affidavit has been exchanged. The contents are not disposed of. ठीक है ना?
You are 49 of 125.
May it please your lordship.
Here, my lordship, London Council Smith Kumari, appearing for the state.
Yes,
Today only received the point by lordship.
yes.
So needs some time, my
No,
lord.
no, one second. This is a criminal motion. I'm not supposed to serve anyone before it's admitted.
Yes.
No, this is a application for quashing.
Where is he? Where is Mr. Sumit?
But I have no idea. But
Yes,
I had informed
Day
you.
after tomorrow, inform me, my lord.
we'll have it day after tomorrow. There's no urgency.
But the urgency in the sense that as far as application number 1 is concerned, the police officers are continuing. Now this is, I'll just give you much of the background very briefly. My lord has dealt with this case on the civil side before, page 105 is that order. There's a mosque here in Port where two groups are both trying to grab it. There are a total of 6 civil matters so far. My lord has passed the order in one of them, page 150.
Oh, yes, yes.
So this background I don't need to get into. Now, in the middle of all these civil disputes, this court froze the mosque bank account and directed the chief secretary to look into the matter and take a decision.
Right.
Now, the mosque needed to be administered for whatever reasons people are using it, it needs to be done. So the Waqf board was asked to set up an ad hoc committee. An ad hoc committee was set up consisting of certain members. Now, those committee members need money to run the mosque, but the bank account is frozen. So they write to the Waqf board and they say, we need to run the mosque, we need money. The Waqf board says, you are authorized to open a new account. Now we go to open a new account, so all the board members take a resolution authorizing 3 people to sign. The petitioner number 2 is the president of that ad hoc committee and is authorized to sign. Now we go to open the bank account, we find the application form, we need to give KYC, PAN and Aadhaar. Mosque doesn't have it. We are the authorized operators, so we submit our documents, the account is opened, and on the basis of that, 3 of us operate that account. Now in the meantime, the civil case has gone ahead and the court says, let there be a committee in place to administer everything. So the Waqf board dissolves its ad hoc committee. On that dissolution, the Waqf board says, since it's dissolved, close down that account, submit all your audits, submit everything. We gave everything in. Now, one of those 2 groups which are fighting with each other comes before the civil court and asks for an election to be held. And let there be an election as per bylaws and let someone run the mosque. Now, this committee unfortunately was a thorn in the side. And these people had to be eliminated. So the group files a complaint, a petition of complaint under 156.3, now 175.3, against the president and all the members of the committee, including the CEO of the Waqf board, who's the deputy law secretary. Now, in this background, he says 3 things. Number 1, this bank account has been opened in the name of the president and his wife. So the wife is in this picture, right? Now, second thing is that they say you all are collecting money under receipts, but there are duplicate receipts. So say for example, receipt number 2 is for 100 rupees for someone. There's another receipt number 2 for 10,000 rupees for someone. And number 3, they say that you all have misappropriated all the money because there's no audit done, nothing is done. Now on the 156.3, the court directs a preliminary inquiry in terms of Priti Agarwala and all those judges. The police does its preliminary inquiry, collects all the papers, bank accounts, everything. But the CEO of the Waqf board says that we can't give you the audit report because the matter is currently under audit. This is the status report of the audit. The police looks at everything, examines everything, seizes everything, takes everyone's statement and files a closure report, saying that this is a civil matter. So far as the lady is concerned, my lord, I will just show your lordship 2 pages. That's all. The first page is at page 213.
Yes.
213, my lord will see the 3rd line. 2nd line, name, Masjid-e-Noor, joint name. Now, Mr./Miss is the format of the computer system. It gives the name of the signatories, authorized signatories. So it says the petitioner number 2, as well as 2 other authorized signatories. It never says Mrs. So and so. On the basis of this Mr. Ms, this gentleman's wife is dragged into the case. She's not in the committee, she's not in the work board, she's nowhere connected with the masjid, she's not connected with the bank accounts. Now the police gives a report saying this lady has nothing to do with anything. And the complainant says no. Why did they print Mr./Miss? She is involved in misappropriation, she is involved in fraud. This is the first thing. The second thing is, so far as the receipts are concerned, the police files a report saying the only reason there are two different numbers is because there are two receipts. One is for members, one is for non-members. So that takes care of the second thing. The third thing of misappropriation, they said we've gone through all the accounts, we've gone through everything, there is no misappropriation. Now this report is placed in the court of the CJM. At that point of time, the CJM hears the complainant who says, no, all sorts of misappropriation has happened. This is a very serious offense. And where is the audit report? The magistrate puts this question to the officer, who unfortunately cannot show the audit report because the work board has already written to him saying the audit is pending. And all of that is a matter of record annexed to this petition.
Yes.
On the basis of that, the magistrate says, well, I don't find your answer satisfactory. I'm directing FIR to be registered and investigation to be started.
Yes.
Now, the factual matrix here is such that going by the orders of this court, going by the orders of the court below, a committee is set up functioning under the aegis of the court orders, under the administration's purview. The factual matrix is something which, honestly speaking, this court is not going to go into and decide on facts. But the legal part of it, when we read it together, is indicating a situation where there is a purely civil dispute, third and fifth conditions of Bhajanlal. Number two, no cognizable offence stands made of. And more importantly, when the magistrate has directed a preliminary inquiry in terms of Lalita Kumari, Priti Agarwal, Babu, I think the third one is Babu Venkatesh, the line of Supreme Court judgments. The magistrate has asked the police to report back. A report back comes back saying there is no offence against the lady. And so far as the other is concerned, there is anyway no misappropriation. Now, at that point of time, the magistrate has a certain responsibility in terms of the criminal jurisprudence and the law laid down by the Supreme Court to verify the situation. And this is why in Priyanka Srivastava, the Supreme Court and a court said a stage has come when all 156 applications have to be affirmed on affidavits.
Where is that order?
Now the difficulty is we are getting no certified copies, but I will show it your lordship from the FIR itself. Kindly see page 99. No, I'm sorry. This is page 190. The FIR starts at page 190.
Yes.
Then at page 194, the entire 156.3, 175.3 complaint is laid out. But the order is at page 194, the top half of the page. This is an order dated 6th August 2025. Today is fixed for hearing in presence of the EO, inquiry officer. The record is taken up for accordingly. The EO and the learned advocate are present. Heard the EO on doc, who submitted that during preliminary inquiry, no incriminating material has been found against the accused persons, and the allegation of criminal misappropriation of property would not be made out. On the contrary, the learned advocate for the complainant vehemently objected the report of the EO and specifically pointed out towards some of the documents annexed in his application. On being asked, the EO could not adduce satisfactory answer as to whether during inquiry they had verified those documents or not. In that event, I think the inquiry conducted is half-hearted and thorough investigation is needed. Considering the above, SHO-PS Aberdeen is hereby directed to register the complaint as FIR and start investigation by deputing a competent officer not below the rank of SIR police other than the present EO. Fixed 3rd November for report in final form. That copy of this order, along with the complaint and annexed, will be forwarded to the SHO. Now, the difficulty is going by the Supreme Court orders. Once a report has been called for, if the report has a defect, there are ways to then deal with that. Now, this sort of a knee-jerk reaction does not reflect that the magistrate has applied his judicial mind, considered the materials, and come to a finding that yes, a cognizable offence is made out. Had you done that in the very beginning, saying an offence was made out, there would have been no difficulty. The very fact that there was a doubt in the mind of the magistrate is what led to this preliminary inquiry in terms of the Supreme Court orders.
All right.
Now, my lord, these two persons are present. This lady who has nothing to do with the Waqf board.
Day after tomorrow.
Fine. Madam, under the appellate side rules, I am not required to serve at the motion
I know.
stage.
That's okay. We'll just give them a
So
chance.
if your lordship so desires, I can give advance for him.
It's not required, not required. It's always easier if you give them, it helps.
No, my lordship friend has given Mr. Sumit Kamakar.
That's all.
transfer.
Copy is there, madam.
All right.
Okay.
Day after tomorrow.
Fine. Keep it.
Respondents will. Is that matter, my lord, the basis of the preliminary decree, my lord, they have prayed for mutation of that land
No, Mr. Where is Mr. Jaipal?
in favor of the legal heirs.
He is well aware of the law. Tell him to withdraw it.
Page 47, my lord.
He was just arguing before me for the division bench.
My,
Knows what exactly is the law. I don't know why he's pressing for it. Where is he? He's coming. Let him come. We'll decide. He knows the procedure very well.
my lord. First, the share has to be divided.
Share has to be
because
divided.
The undivided share and without the partition commissioner, appointment of
He
partition
knows it,
commissioner.
madam. He was arguing 2 matters, 3 matters he was doing today.
My lord.
Same issue.
So, my lord, how the mutation will.
Yes, Mr. Jaipal. No problem.
My point is very.
Your point is very clear. You know the law also. I'm surprised that you're arguing this.
My understanding.
Since morning, you have been hammering us with the same point. And now you want to argue contrary to this.
Preliminary decree, it's the rights of the party.
Preliminary decree decides the share.
Share.
Final decree will decide. And then you need to move an application before the, who knows better than you do, Mr. Jaipal, please.
I have a right to persuade, my lord.
Mr.
I
Jaipal,
have a
you-
right to persuade, my lord.
no, I will hear it. I will decide it also. But I'm just saying that who knows better than you? You were the one who was arguing this matter.
True. There I have different resolution. Now I have a.
Yeah. Mr. Jaipal, you want to.
Kindly.
No, you argue. That's okay.
Kindly give.
No, I will hear you also. I'll decide it. I'm just saying that you know the law. You understand what you're arguing. I know you have to argue because you have to argue. But the point is, you also know on the basis of this, they can't do mutation. This has not really decided the share of the property by mates and bounds. And you know how that has to be done. You know, since morning you have been hammering us with this mates and bounds. Anyway, you decide. If you want me to decide it, I'll reject it. But you know,
Can I take this matter to the next time?
no, I'll decide it.
Because in division, then my lord have.
Mr. Jaipal, I'm not going to leave you.
But may I raise it few things?
Yes,
Just
please
to
do.
what extent the Tahsildar can mutate based on the preliminary decree's action? Brought to see the regulation 84 and 85.
All right.
Mutation in these islands is done in terms of the local regulations, regulation 1966, looks at
Dikhana.
regulation 84.
Where is Shob? You have
84 exclusions. But by that, preliminary decree rights have been accrued in my favor. So Tahsildar simplicity have to hold mutation. So for us.
can't do it.
The final decree exercise one of those partition commissioner's report, final decree simply would allocate the share. This has nothing to do with.
It will decide by meets and bounds. Then you have to go before the commissioner, and that's why I said, who knows better than you do? Because since morning you have been just hammering this point to us. Anyway, which
84, Lordship, regulation 84. So by this regulation 84. So by virtue of preliminary rights have been accrued, Your Worship, I have acquired right title. If I have acquired right title, mutation has to be done in terms of the field. That's the sorted point. It does not turned out. So if you
Yes.
or to see. Not to see the improved order. This was not the reasoning assigned by the Tahsildar, but the reasoning is something else. Tahsildar says to approach the appropriate authority. Not to see the improved. Page 15 of the petition,
Page.
51, annexure T3.
Yes.
Tahsildar have relegated me to some other authority. So letter communication dated 20th of June 2025.
Yes.
And basically,
Yes. Yes.
with reference to the above, it is hereby intimated that the Honorable Court of Joint Civil Case Division has directed the plaintiffs and defendants are liberty to partition of the suit property amicably and demarcate and hand over their respective shares by others to the extent as mentioned in the judgment. Furthermore, as readable from the case record, it is observed that there is no amicable settlement between the parties. Moreover, there is no direction passed by the Honorable High Court, Honorable Court, to the undersigned to subdivide the suit scheduled property. Be that as it may, the plaintiff may pursue in accordance with law before the appropriate forum by furnishing latest records of right, land revenue receipt and proposal map, delineating the shares of each party. The Tahsildar have said to approach me to the Deputy Commissioner for subdivision. But my case was not either for subdivision, because I am simply saying that since based on theoretic rights have been accrued in my favor, do the demarcation. Because demarcation would indicate the portion of share as declared by the preliminary decree.
Yes.
As regards
Commissioner will
demarcation.
Yes.
As regards demarcation, as regards allocation of shares, this is the exercise to be undertaken while drawing up to the final decree. That's my point.
Yes, Ms. Babita.
Ma'am.
Yes.
My lord, first of all, my lord, it's only on the basis of the preliminary decree, my lord, they have of
File the application.
filed the application for mutation, my lord.
Page 48. Right?
Page 49, my lord. That acknowledgement receipt, they have applied for
Application is
mutation.
48.
Page 49 is the applied for mutation, my lord.
Yes.
My lord, on the basis of the preliminary decree, my lord, the share has to be divided. Who will divide? They will file an application for appointment of a partition commissioner. Partition commissioner will divide the share and they will file a report. Thereafter, a final
He
decree
knows.
will be drawn up, my lord.
Mr. Jaipal, no.
The
Yes,
shares-
take down. Take down. The petitioner
Right.
has referred the presented petition assailing the communication dated 20th June 2025, passed issued by the respondent number 2, whereby the petitioner was advised to pursue his remedy before the appropriate forum by furnishing the latest record of rights, land revenue receipts, and a proposal of map delineating the respective share of the parties. Full stop. The learned counsel for the petitioner states that the learned joint civil judge, senior division, Port Blair, passed a preliminary decree dated 26/4/2024 in suit number 72 of 2015. Pursuant thereto, the petitioner submitted an application dated 3/3/2025, followed by an online application dated 20th. This is 20th, right? 20th May 2025, before respondent number 2, seeking initiation of proceedings under Section 84 and 85 of the Andaman and Nicobar Island, Andaman and Nicobar Island Land Revenue and Land Reforms Act 1966, comma, for mutation of the property. Full stop. However, comma, by communication dated 26/2025, comma, respondent number 2 rejected the said request, comma, directing the petitioner to approach the competent authority. Full stop. Being aggrieved, the petitioner has approached this court. Learned counsel for the petitioner submits that by virtue of the preliminary decree dated 26/4/2024 in suit number 72/2015, comma, the shares of the parties already stand determined, comma, and as there is no challenge to the said decree, comma, the respondent authorities were duty bound to effect mutation in the name of the respective shareholders. Full stop. Per contra, learned counsel for the respondent, Ms. Babita Das, contends that mutation cannot be carried out on the basis of preliminary decree, comma, inasmuch as the same merely determines the shares of the parties, but does not finally effectuate partition by metes and bounds. Full stop. It is only upon the passing of the final decree, comma, which conclusively determines the right and possession of the parties, comma, the mutation can be effected. Full stop. Hence, comma, in absence of a final decree, comma, the application of the petitioner has been rightly rejected wide order dated 20th June 2025. Full stop. This court has heard the submission advanced by both the counsel for the parties and has produced the materials on record. Full stop. The sole issue arising for consideration is whether mutation can be granted on the basis of a preliminary decree. Full stop. It is well settled that a preliminary decree, comma, by its very nature, comma, merely declares the shares of the parties and leaves further proceedings, comma, such as division by metes and bounds, comma, delivery of possession and preparation of the final record, comma, to be undertaken for passing of a final decree. Full stop. Mutation in revenue records, comma, being an administrative act to reflect actual title and possession, comma, can only be carried out on the basis of a conclusive adjudication of rights. Full stop. Since a preliminary decree is interlocutory in course of final decree proceedings, comma, it cannot form the basis for mutation. Full stop. In the light of the settled legal position, comma, this court finds no infirmity or illegality in the impugned order dated 20th June 2025, passed by respondent number 2, full stop. Accordingly, the present writ petition stands dismissed. Next. Yes,
Arjun for the petitioner, Your Lordship.
yes.
This is related to the value-added tax dispute.
Who is that? The respondent.
My senior appears on behalf of the respondent.
Yes, where is?
I pray for short pass over.
Your Lordship, they have already taken the other similar matters, trying to file their affidavit in opposition. And there was an interim order passed by this honorable court in that regard. Until then, the impugned order had to be stayed. So I pray that a similar order be passed by this honorable court in the.
Which is that order?
Your Lordship.
What is the date of the order here? Where is the impugned order?
Your Lordship.
Page? Page 43.
Page 43, Your Lordship.
What is the date of the order?
The date of the order is 22nd July 2020.
Take up. The petition,
One thing, in this particular petition, Your Lordship, already there is an interim order which is existing,
in this one,
Your Lordship, that there was an interim order until 31st of August. I am saying that we reinforce and extend.
where's the affidavit in opposition, madam?
Time to file.
Or time was already given to you?
It may be given, 2 weeks time may be given, Your Lordship.
Learned counsel for the respondent seeks and is granted further time of 2 weeks to file affidavit in opposition. Full stop. Reply to the same, if any, within 1 week thereafter. Full stop. The interim order granted by this court wide order dated August 8, 2025 is extended further for a period of, this will go to November, right? Kitna ho jayega? 8 weeks.
The similar matter stays before court number 1, Your Lordship, it was extended till at the end of November.
End of November. Is extended till 30th November.
Item number 8, 9, 10, 11, 12, 13. 8 to 13 and item number 40 are similar matters.
All notices have been issued.
Your Lordship.
Stay is there in all the
There
matters.
there is existing. Sir, has to be
14.
extended.
All right. Same order in
8 to 13 and
8 to 13 and
40.
40. 8 to 13, same order, and 40. And 40.
Right, Your Lordship.
My lordship,
Yes.
and rest of the matter will kindly be taken tomorrow, my lordship. We are feeling hungry, my lordship.
You are
Almost
feeling
it is 2:10, my
feeling
lordship.
hungry and I'm not feeling hungry.
Everybody means.
Lordship, in item number 59, saying extension of time to file my opposition.
Who's for the petitioner?
So Vijay Kumar is appearing, but I have not
He's
filed.
not here tomorrow.
Lordship.
Rest of the matters tomorrow.